Oftentimes, when people think of distracted driving, they oftentimes picture someone who's texting behind the wheel. But distractions can take many forms, and some of the most common involve everyday habits like eating a snack or even just fixing your hair. In Missouri, these seemingly harmless actions can have serious legal consequences if they lead to an accident. If you've been injured in a crash caused by a driver who was eating or grooming instead of paying attention to the road, you may have a legal case. And in this video, we're going to explain how Missouri laws view these behaviors, why they're dangerous, and how to hold a negligent driver accountable. But first, let's just talk about what distracted driving is. Missouri law looks at distracted driving very broadly, and it can include many different types of activity. But broadly speaking, there's typically three different categories of distracted driving. This can include visual, which of course is taking your eyes off the road. This can include manual, which is of course taking your hands off the wheel. And this can include cognitive, which is taking your mind off of driving. Something as simple as eating a cheeseburger while steering or checking your reflection in the mirror to apply makeup may not seem risky at all, but they can involve all these three types of distraction. And there's some simple examples we can discuss that may constitute distracted driving. Some common examples include eating fast food or drinking coffee, unwrapping food or reaching for napkins, even putting on makeup or fixing your hair, and adjusting clothing or accessories. Finally, something that you may seem odd, but we've seen it happen is flossing, shaving, or even using an electric razor. And while Missouri does not have a law that explicitly prohibits eating or grooming while driving, drivers may still have consequences if they operate their motor vehicle and are distracted. And these behaviors, if they lead to a crash, they can have significant legal consequences on their life and others. And Missouri distracted driving laws exist. They exist to address the safety concerns that exist when people drive while not paying attention. And there's even specific laws that deal with hands-free cell phone use. Some of the legal risks that exist if you were to eat or even groom yourself behind the wheel is that there can, of course, be traffic citations. You can be given citations for careless and imprudent driving, citations for failing to maintain and control the vehicle, or even for following too closely or running a red light. All these citations can result in fines, points in your license, or even higher insurance premiums. In addition, there can be civil liability if you're involved in an accident while being distracted. If the distracted behavior caused the crash, the driver can be held financially responsible for any resulting injuries or damages. Victims can pursue a personal injury claim, seeking compensation for their medical bills, their lost wages, their pain and suffering, as well as their property damage. The key really is going to be proving that the driver's actions were negligent and that the distraction, whatever it may have been, directly led to the collision. If there is the evidence and the proof that the distracted driving led to the collision, then there can be increased fault in a comparative negligence case. And Missouri specifically uses pure comparative fault. And what that means is that your responsibility and the amount of damages paid may be in proportion to the percentage of fault that you had for causing the accident. So if you were doing something which causes you to be distracted and ultimately led to the accident, you may be assigned a specific percentage of fault for the accident. Also, in some cases, although usually more extreme cases where there's distracted driving, a court or a jury can actually award what's called punitive damages. And if you have a situation maybe where you have high speed crash or willful or even reckless behavior, the judge can award those punitive damages, which are meant not only to compensate the person who was injured, but also meant to deter the person who caused the injuries. So how do you prove the other person was eating or grooming and was distracted at the time of the accident? Proving this sort of information does require gathering strong evidence, and they can include a lot of things, such as witness testimony, things like passengers or bystanders who have seen the behavior. They can include police report, which may be officers noting that there was some distraction that was present or some witnesses indicating that they were distracted. It can include photos or video, which could be from dash cam, surveillance footage. It can also include physical evidence, things like spilled drinks or open food wrappers found in the car. And finally, there are sometimes admissions by the driver. Some drivers just simply tell officers a lot of different things, such as that they were distracted when the accident occurred. And oftentimes, personal injury attorneys can help secure the evidence so that you can use it later when necessary to prove up your case. So what do you do if you've been injured by a distracted driver? Well, if you think that the other driver was distracted, eating, grooming, whatever it may have been, first off, call 911 and report the accident immediately. You also want to tell the officer what you saw. If you saw them eating or using a mirror, whatever it was, make sure that they tell the officer so that it can be noted in the police report. Also, take photos of both vehicles and the scene. and look for any visible signs that the other person was distracted. Make sure that you get medical treatment, even for minor injuries. Sometimes the adrenaline can be really high after an accident, and you may not know the injuries occur until sometimes days or even weeks later. Don't speak to the other driver's insurance company without legal advice. Oftentimes, their goal is to get a recorded statement, and those recorded statements can and will be used against you if given the opportunity. And then finally, contact a personal injury attorney who can investigate the case and preserve any evidence before it disappears. Why is it so important to have legal representation? Well, holding a negligent driver accountable for the distractions like eating or grooming can be really challenging, sometimes more challenging than texting or phone usage. And insurance companies may argue that the distraction wasn't serious or that it didn't contribute to the accident. And your attorney can investigate the scene, they can subpoena videos or crash evidence, they can prove negligence through traffic laws or expert analysis, and they can negotiate or litigate what compensation you deserve. In summation, eating and grooming may seem like harmless multitasking, but behind the wheel, when there can be deadly consequences, Missouri drivers are expected to maintain full control and attention when they operate their motor vehicles. And when they don't, if the innocent person is injured, then they must be held accountable. If you know somebody or if you've been involved in an accident, contact our firm so that we can help.